This program is being recorded on November 1st, 2007. The CPI report, Child Protection in Iowa, brought to you by Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15. It airs on Sunday afternoon at 1 o'clock and again on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com or give us a call, parents that need some advice and encouragement in the issue that you're facing. My number is 515-276-3956, and John's number is 515-282-2672 in Des Moines, Iowa. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. That's Child Protection in Iowa, brought to you by Vocal of Iowa. We intend to follow two pursuits. Number one, to influence public policy as it relates to child protection issues. And secondly, we attempt to assist people. We're not lawyers, but we attempt to assist people who are having difficulties with the Department of Human Services and the Juvenile Court, and that is an ever-expanding group. And we believe that the department is on the wrong track, and we believe that there is reason to believe that the courts that are involved are also on the wrong track and should be reformed. Perhaps they need some schooling, and I suspect in order for them to reform. I suspect we'd call that a reform school, wouldn't we? So we're going to talk to someone today, or have someone talk to you regarding the kinds of court reforms that are needed. We may not speak specifically of recommendations for reforming those schools, but to point out some of the problems that are existent in this area. And I'll be coming back and speaking a little bit about some of the problems that are existing in the area of what we call EMC, which is called Expanded Media Coverage. The reason why I wanted to speak about this is because personally I've run into some difficulties. The Iowa Supreme Court has made it crystal clear that there is supposed to be respect for something called openness. That means the courtrooms are open. That means that people can attend, and that there is an openness to videotaping in courtrooms, with some restrictions, of course, and with pretty heavy-handed supervision with respect to how that is handled in such a manner that it doesn't disturb courtroom proceedings. Well, that's enough of the title of or the direction of where we're headed on today's program. But for right now, let's find somebody who is a real champion of justice and the justice system, someone who is the judge of the judges. Let's turn to Terrance Walker.
Well, thanks a lot, John. I always like your introductions. Yes, I am the judge of judges because nobody in
Mike.
Iowa can do it better, and I guess nobody can hear me. Is that better? Yeah, I'm the judges of judges here in Des Moines, Iowa, and like I said, nobody could do it better. Nobody is doing it because nobody is an actual. There's no official or unofficial department that I feel adequately reviews the judiciary.
How about in other states?
Um, Other states, well, they have something similar to what we have in this state, which is the Judicial Qualifications Commission. And most of those commissions, I feel, are very inadequate because they really give a rubber stamp to the whole complaint process, and they wholesalely deny or find unfounded all the complaints against judges.
Are there organizations that stand up against judges?
Yeah, there's a few I think that are admirable, do an admirable job, just like the one organization, Jail for Judges. They tried numerous instances to enact what I feel would be a pressing reform as it pertains to the judiciary, where they have some sort of three strikes and you're out policy against some judges, and basically would enable what would be citizen appointed um, grand juries, which can investigate judges and not only sanction them, strip them of their immunity, but can also leave them open to be sued. Because a lot of people don't realize this, but judges are immune from suit. Unless they go out and like hit you in the face. But anything they do while they're in the judge office or anything they do in that capacity is basically protected, and they can do anything they want. They can
I think it's called "The King Can Do No Wrong."
Right. It's a policy that goes back to England, and we're supposed to be a nation that has separated from England a long time ago. That's what the American Revolution was all about, I thought. But the judges and their grab for power in the early or late 1800s basically said that the judges can do no wrong, and they granted themselves through a judicial decision. I can't remember the name of the decision. I'll look it up later. I'll have it for you on next show. But through the judge's decision in a Supreme Court case, they basically said, well, we can do no wrong, and it would make no sense to sue us because it would just create a tidal wave of litigation. Granted that there is some merit to that argument. However, the reasoning that they were relying upon were not stuff that was written in the legal books, and so they basically ad-libbed on their judicial decision and made up law. And that's what we really try to talk about here on this show, so when judges do bad things. But sometimes we want to talk about when judges do good things because we want to show what a shining example of a good judge should be. I have a couple of good instances here. I think highlight a couple of, well, several good judges. We got an article here from the Village Voice from October 30th by Nat Hentoff. He writes about the national security letters. Now, since 9/11, the president and his advisors have aggressively capitalized on Americans' fear of additional terrorist attacks by insisting that our safety can only be secured if the executive branch is allowed to override Congress and the courts when necessary. For example, George W. Bush has attached signing statements to many of the bills he has signed into law, stipulating that he can ignore those laws if he decides they endanger national security. Now, both Congress and the federal judiciary have largely deferred to such an unprecedented expansion of presidential powers, but there's a growing rebellion among certain federal judges against this imperial rule by fear. An example is on June 10th, when Judge Diana Mott of the First Circuit Court of Appeals wrote in an opinion, "We refuse to recognize a claim to power that would so alter the constitutional foundations of our republic." Now, in the case that she was handling and discussing in the opinion, it was a case of Ali Almari. Now, he had been in prison for 4 years at the Navy Brig in Charleston, South Carolina. He had been arrested in Peoria, Illinois, while living with his family and studying computer science at Bradley University. He was suspected of, but not charged with, being an Al Qaeda sleeper agent. Now, he was pulled from the local criminal justice system because he was being charged in a credit card fraud case. But they took him from there, and they held him in the military brig as an enemy combatant. And that was by designation of the president. And what Judge Mott said is to sanction such presidential authority to order the military to seize and indefinitely detain civilians would have a disastrous consequence for the Constitution and the country. Charge Al-Mary, she ruled, or deport him, or hold him as a material witness, or release him. This still being America, she ordered the trial judge to issue a writ of habeas corpus, thus freeing him, which is a rare instance. I don't know if you're aware of how tough it is. Since 1996, they passed a law which basically made it impossible for you to get relief from a federal court on a writ of habeas corpus.
That's thanks to President Bush.
I think that was thanks to President Clinton, one of the not so good things he did.
But I understand it's getting tougher and tougher as the years go by.
Yeah, it's getting more and more impossible, and we're getting to be a really repressive society, repressive and authoritarian society, and it's good to see that some judges can reflect back on the foundations of this country and the foundational documents and the underlying meanings of those documents, and can read them into current situations, and where they have the guts to actually make a ruling which goes against the grain. So I think Judge Motz needs to be applauded. Another district judge, another federal judge, however, federal district judge Victor Marrero, he has twice ruled that the national security letters authorized under the Patriot Act are unconstitutional for shredding both the First and Fourth Amendments. The national security letters give the FBI virtually unlimited power to demand, without first going to a judge or getting a grand jury subpoena, personal records from banks, telecommunications companies, and other institutions. In his first ruling on FBI secret searches 3 years ago, Judge Marrero overturned a startlingly broad gag order that prevented these institutions from ever telling the people under investigation that their right to privacy under the Fourth Amendment had been summarily breached. Responding to Marrero's sharp lesson on the Bill of Rights, Congress made a pass at amending the Patriot Act in 2005, adding a provision that supposedly allowed these institutions to challenge the FBI gag order before a federal judge. But on September 6th of this year, Marrero, in a stinging 103-page decision, knocked down this flimsy congressional repair job, which he found still allowed the government to violate the First and Fourth Amendments. Since many Americans don't have the time to read the 103-page decision or know where to find the handful of news sources that summarized it, few citizens are aware how deeply these national security letters allow the government to burrow into our private lives. And an example is in one of Judge Marrero's opinions. He wrote, "Through the use of NSLs, which are national security letters, the government can unmask the identity of internet users engaged in anonymous speech and online discussions. It can obtain an itemized list of all the emails sent and received by the target of the national security letter, and it can then seek information on individuals communicating with that person. It may even be able to discover the websites an individual has visited and queries submitted to search engines, and it has been able to do this in total secrecy." So if you're online on the internet, you don't have any privacy anymore. They can basically search you and use that to eventually detain you, and who knows else what they might be able to get to you. They might be able to get your financial information, and just because of something you said on the internet. So you have no rights anymore. Judge Victor Marrero, I hope, is an inspiration to other members of the federal judiciary. And since the case is still on appeal, perhaps the Supreme Court will chime in on the issue. And I would like to touch base here at home. we've got another judge here. Usually judges are in cahoots with the executive branch, and they just do whatever they want them to do in a lot of instances. We've got a judge here locally in Iowa, Judge Brad Harris. He's out of Cedar Falls. Which district is that? You know?
Not sure.
Not sure. Okay, Cedar Falls area. And on October 24th, the Register reported a judge this week upheld the firings of 3 Cedar Falls police officers accused of misusing their clothing allowance. Officers Josh Atterbury, Joe Otteraj, and Holly Poe were fired in September '06 for allegedly misusing their $475 allowance meant to pay for uniforms and required to work clothing. The city accused the officers of purchasing the clothing and later returning them to the stores and keeping the money. Department policy requires the officers to return any unspent clothing allowance to the city. A 4th officer, Brad Brown, had also been fired at the same time. His job was reinstated last year by the Cedar Falls Civil Service Commission. The officers have argued the city's policy is often misunderstood and that they did not deserve to be fired. District Judge Brad Harris ruled the officers' actions violated the public trust and warranted a severe reprimand. Any attempt to handle this matter informally will result in greater controversy and erosion of public trust, he wrote. Now, I think that that's one instance I will say an Iowa judge did the right thing, because usually they capitulate to the powers that be and do what the powers that be want to be, whether the powers that be the child protection services, whether they be the police, whether they be the prosecutor's office, or whether they be whatever government body that is representing the citizen of in the court. So I would applaud that, and I wish we would have some more judges here in Des Moines that would do that. We've had a few. Because we've got some serious problems with the police here that are going unnoticed and unchecked. One instance I would reflect upon back a couple weeks ago when I relayed a story about an officer, Lloyd of the Des Moines Police Department, who I said was not only a little bit socially, I'd say socially, he had a little bit of social economic prejudice in his views and his viewpoints. Not only that, but he could lie really good on paper. And we've got to really scrutinize these officers when they're out there trying to gain convictions or trying to arrest people, and they falsely put stuff down on charging documents so that they can get more notches in their belt, so to speak. That goes on a little bit more than a lot of people would think, because I know a lot of people from a lot of different walks of life, and I've listened to a lot of stories out there, and I would say that whereas the average person might not believe a person who has been in the system or has been harmed by the system, we tend to think, the average person would tend to think, well, that doesn't really go on. That does happen. So we need judges that can stand up and check these things. That's what they're there for. That's why you see the blind lady with the lady with the blindfold with the scales in the front of or on a lot of the courthouse doors or buildings, because that's what they're supposed to be representing. Someone who can blindly weigh the scales and not tilt them in one side or the other.
Right.
But that's my little 2 cents. I know you guys have a lot more to cover on the show.
Okay. Good enough. Well, thank you, Terrance, for those comments. I promised I'd talk a little bit about EMC. I used to know EMC as Employers Mutual and Casualty, but I've come to know it more recently as extended media coverage. What that means is cameras in the courtroom. Is it a good idea? Yeah, under the Sixth Amendment, you have a right to a free a free and open public trial if you're accused. Courtrooms should be open, should be not a spectacle, but should be a good academic exercise. And to me, the courtroom should be a sanctuary for the development of the truth of a matter. Should be a serious and sober situation, not a conniving bunch of expensive lawyers and wicked judges in charge here. I see, regrettably, some real problems here, particularly since watching over some courtroom battles, and also particularly in this business of extended media coverage. You see, about 25 years ago, the Iowa Supreme Court made a determination that the watchword for cameras in the courtroom was supposed to be openness. Openness means allow them. Unless you have a specific reason for excluding a camera in the courtroom, the districts were told to expect cameras to be there. Now they have given that over to an organization called the FOIA, the Freedom of Information Commission, a branch of the Department of Journalism at Drake University. And this organization is supposed to dictate the facilitation of that order to have cameras in the courtroom. Ever since then, during that 25 years, much like what has been happening in the Sunshine Law, all kinds of devious exceptions have arisen, such that the privileges of the press have been greatly diminished. New rules, new this and new that. One of the most regrettable things that has happened, or at least the Polk County should regret it, happened on March the 24th, in which a friend of mine wanted to engage in extended media coverage for his case. He was ticketed by Des Moines police, and he believed that to be unfair, and he thought it would be wise to publish that as a news item. Well, I'm a news gatherer, and I walked into the courthouse with a camera. I also had, I can't say I had permission, I had made previous arrangements to have a camera in the courthouse. I followed all of the rules, the canons, and knew full well just how that was to go. I was followed around the courthouse by a deputy who was constantly harassing me and attempting to tell me just how things were to be. One of the first things that he invented was a requirement that when you enter the courthouse, you must have a signed order by the judge. No one has signed orders who goes into the courthouse with their cameras. They make the arrangements with a fellow by the name of Jeff Greenwood, who works with a high-profile company called KCCI, a subsidiary of the Hearst publication industry, a huge journalistic outfit, but he serves in a more private capacity as a coordinator of EMC. I had already made arrangements with him, and he had already filed papers with the court, so the court knew that I was coming to make application. But this deputy took it upon himself to say, well, you have to have an order in hand when you walk into the courthouse. No, you don't, Mr. Deputy. And he said he had to follow me around the courthouse. He said, and there's also a wicked judge down there who directed his movements around the courthouse, and said for that deputy to keep me under surveillance because I had a camera in the courthouse. Well, you see, what they're trying to do here is to make it so difficult and so unappealing to people who have cameras that they don't want in the courthouse. By the way, people who have cameras in the courthouse might reveal the truth of the matter of what goes on in the courthouse. And that is not something that should be shared with the general public, right?
I think you hit the head on the head of the nail with that one, because that's what they're really scared of. They're afraid of publicity.
Yeah. So
know.
keep those cameras out, and we'll have a much better time of it, right?
Yep, we do what we want.
You bet. Well, anyhow, that went on to the point where the deputy decided to, without warrant or reason or provocation, arrested me, threw me in the county jail, took me to trial, where I was found guilty by a jury. I wonder why. I took that matter to a judge who apparently on that particular day was acting in a manner which was consistent with the law. He had read over all of my pleadings and decided that what I was pointing to, such as the Iowa Constitution, the Iowa Rules of Criminal Procedure, and the Iowa Supreme Court rulings, prior rulings, said that when a deputy files on someone, he has to swear out a warrant, and he has to swear to that warrant as being true and correct. He didn't do that, and so they overturned the whole thing. I got all my transcript costs. I got refunded on all of my activities in court and so forth. And now, of course, I've turned around and filed a federal case. So it's going to be kind of interesting to see how they attempt to sneak out on their obligation to obey the same laws that we're required to obey. It would be nice if public officials were held to the same level of obedience that we are to the law. Well, the most recent problem I've had with EMC is where I've asked for EMC coverage for a case, and now they want to cut back on the amount of the grant of EMC. In other words, you can have this piece of the action, but we're not going to let you have any more of it. So that's discouraging. And then
So
when I asked,
what do you mean by that, though?
well, for instance, I requested to have, in a particular civil case, I wanted to tape everything that happened in that civil case, no matter how many hearings there were. But he said, no, you can only have the next one, and that's all. The next piece of the case, but no more. When I requested from Jeff Greenwood, he waited for 2 weeks. I had to follow up on it and find out why he wasn't preparing the paperwork. He says, well, the judge has already said that you can only have one piece. Well, I said, excuse me, ask him again. Well, they're going to decide whether they should ask again. Now, does this deviate from the concept of openness in the courtroom, openness to cameras, Terrance?
I don't know. It sounds awful fishy to me. Why can you only record one proceeding? I don't understand that. Did he give a reason behind that?
He gave no reason in his ruling, and unlike any other such case as this, where I've asked for EMC, he actually held a separate hearing and called me to the stand and asked me what kind of equipment I have, how do I move from the questioner to the person who answers, and I said, Your Honor, I may have to pan from one to the other. He wanted to know who owned my equipment, wanted to know what I was using the equipment for, and I said, I'm news gatherer. That's why I bring the equipment to the courthouse. And with all that, now he's been very gracious, I must admit, in accommodating my setup in his courtroom for expressed a good deal of interest in the recording. But nevertheless, and now I'm supposed to tell security 24 hours in advance that I'm coming to the courthouse. Well, excuse me, isn't security on board at the courthouse? Don't they know when I come to the courthouse? Can't I just tell them I'm here? All kinds of silly things like that to make it less easy for me to accomplish my work. In
So
some
what
cases,
are you supposed to? Are they making these rules for everybody? I don't understand.
it's hard to tell. My argument is this: if they're treating me differently on different days, I couldn't care less if they're. Oh, it looks like we've got some little bit of audio problem here. Okay, there comes the audio back on again. There's a problem if they can't treat me the same way from day to day. If they can't treat me the same way from day to day, how can I be assured that they're treating everybody the same? Well, so much for EMC. We'll figure out when FOIC decides whether or not they'll follow through on their obligation and duties. They think that I should have to go back to court and file a suit against the judge or file it on my own. And the suggestion was that I hire an attorney. They also suggested that, number one, that the openness is only for criminal cases. Well, excuse me, cameras in the courthouse, when the Iowa Supreme Court spoke, didn't say anything about civil cases and criminal cases, treating those differently. Well,
That's bizarre.
Pardon?
That's very bizarre.
Isn't it
They
though?
would make those distinctions. And now they want to split hairs.
Now they want to split hairs,
They
yeah.
want to say, oh, you can't go. Well, this only applies for criminal matters and not civil matters. And
Right.
we could have you come to this proceeding, but not that proceeding. And
Right.
you got to come 24 hours in advance. I mean,
You got to warn
You know.
security 24 hours in advance that you're
so
coming.
what role does the FOIC play? I mean, are they just going to sit? I mean, are they just?
They're designated by the Iowa Supreme Court as coordinators of all these services, and so they have 8 district offices in which they designate people in those local organizations. Now, of course, they're going to have to designate people who are mainstream media. That means the big shots in the media, the ones on commercial television. I think that was one of the complaints, is because I don't put my program on commercial television
Well, you
stations.
shouldn't have to. I mean, this
No.
is news. What we're given is news.
This is news, and it's established under franchise with the city of Des Moines to be an alternative news gathering source. And I don't think they particularly like voices that don't match with their voices. I could be wrong. And by the way, if you think I'm wrong, why don't you come here and take Terrance's seat and tell me why you agree with this kind of behavior? Cut off the guy who wants to speak person to people and go in courtrooms and record. By the way, my camera has never lied about one fact that it picked up in court. It tells it precisely the way it is, and it's hard to argue against that. So we're going to move.
Well, people don't like the truth. That's the problem.
That's the biggest problem.
And if we have judges that don't like the truth, we need to get rid of them judges. And what was the judges that you said gave you all that grief?
Well, there was a gentleman by the name of William Price, William Price did a magnificent job in a high-profile case here to defend a father whose child unfortunately died when he was in sixth grade, and the father was um, accused of child endangerment for not taking him to the doctor uh, as the courts wanted him to. He took him to the doctor. In fact, he had decided to take him to Mayo Clinic. William Price did a magnificent job, and I was pretty proud of what a Des Moines attorney could do in that particular case. However, maybe he did it by accident, because he certainly hasn't shown himself to be uh, a wise judge. By the way, I did name him in the federal suit. And guess how he managed to slip out, Terrance, of the federal suit? It's called
Because the judges in that case capitulated to the powers that be.
immunity.
Exactly. What we were just discussing.
Unqualified immunity. By the way, his immunity was invalid because he was operating in an administrative capacity, not in a judicial capacity. Having a deputy follow me around the courthouse had nothing to do with any case that he was working on, had nothing to do with judicial determination. So we may have to fight that one out. Well, I want to turn real quickly here to listen to what the Department of Human Services says. One of our favorite characters over there by the name of Mark Chappelle is explaining a little bit about how they do business in a 13-county area around Polk County. Here now, we'll turn to Mark Chappelle with the, well, let's see, maybe we better get over to another channel here. The first person you'll hear from is Mark Chappelle.
I'm going to talk just a little bit about service array and about what we do with ongoing cases. And the first thing I want to start you off with is just kind of a picture for you. I spent the last 6 days in Philadelphia, and one of the things that we did while we were in Philadelphia is we crossed the Walt Whitman Bridge from the New Jersey side. I don't know if any of you are familiar with Philadelphia at all, but when you cross the Walt Whitman Bridge from the Jersey side of Philadelphia, off to the right, just before you finish crossing that bridge, there's a ship there. And that ship is the SS United States. And that ship holds the fastest record, stands today. That ship was retired in 1969. That ship holds the transatlantic record. It's never been broken, just under 3 days. Though that ship sits there today in somewhat derelict shape, its hull is sound and its turbines are sound. That ship, in some ways, represents, in my head, where we were with services several years ago. We had a sound hull, we had good turbines, but we weren't bringing it together. Where we are today with service array, I think, is that ship or even more. What we have been able to do with the framework of services and the perspective that we have today on services is to build, as Wendy pointed out, a common language of talking about where we're going to go, where we've been, and where a family needs to get, and what families really need to do in order to get themselves safe and move on and grow as a family. In some ways, what happened at service handoff between CPA and service was that we would, Beth's last slide was a little baton there, okay? And I think that baton represents some very good things about services. Number one, it represents a common language. Number two, it represents some engagement through the family team process. Number three, I think it represents, in some ways, the targeted safety services that we're going to work with families on. And that's really, in many ways, what the focus of our service is going to be. In the past, when we have handed off cases, CPA may have thought that they gave us a baton. When the worker got it, they thought they got a table lamp. When the service provider got it, they thought they had a mop. So when it came time for families to work on things, they didn't know if they needed to take the baton and run with it, go turn off the table lamp, or mop the floor. So folks really didn't know what it was they were supposed to do. Now sometimes things worked out very well. If we had good social workers who had a good idea about how to engage with families, things happened. But it didn't happen in an organized way. It didn't happen as a fluid motion, as a thoughtful, deliberate, kind of focused process. As we looked at service referral, or what we used to do with services, we used to have families, we used to tell a provider, okay, go serve this family, and where we want you to get to is someplace down in southern Iowa down here. And what we're going to do is tell you how to get there. We're going to tell you what roads to take. We're going to tell you how fast to drive. We're going to tell you what corners to make. And we're going to tell you when you ought to be there. That may have worked for some families, but it didn't work all the time. With our new service array, though, what we have are a couple of things that are going to happen with families. Number one, we're going to have safety plan services. And Beth has alluded to some of what's going to happen there. And I'll talk just a little bit more about that. Second piece of that is going to be a family safe risk and permanency services. That's the FSRP thing that I'm talking about now in terms of the ongoing services that we have. Safety plan services were very focused on safety risk, on risk kinds of things, or safety kinds of things for kids during a child protective assessment. Family safety risk and permanency services are those services that are focused on families in an ongoing sort of way. They're the kind of things that are going to get families from where they started to the other end of the service, of their service event, or their service life, through the life of the case. You want to give me the next slide? Thanks. We kind of changed our case definition as well. Well, we didn't kind of change it, we did change it. What we had before was a model that was really focused on kids. And there wasn't anything necessarily intrinsically wrong with that. I mean, how can you fault being focused on kids? But the problem was that you had to bend services around with that to make it fit within a medical model. So what we did a lot of times is we would determine what a rehabilitative need might be for a child, and maybe the child had some rehabilitative needs, maybe they didn't so much. Maybe it was more a family kind of, maybe it was more a parental kind of issue. It was a fault in parenting, the parents that hadn't learned something well, or didn't have skills, or needed other resources. Well, trying to make that fit in a medical model when it's focused on kids was pretty tough. And providers and the department, I think, had a very difficult time trying to make that work in a way that was supportive and beneficial for families. What we have moved to is a more family-focused perspective on service. In other words, instead of a case being a child now, a case is a family. It's a family unit. So that supports in many ways the engagement we have with families. We can talk the same kind of language to families, to providers. We can address those kinds of needs, and we can be sure that the things that we're doing, the resources that we bring to bear on families, are going to support the family in a system sort of way. We're not going to treat just this one small piece over here and hope that somehow, by osmosis, that filters out in the family and make things better. We're going to do that in a planful, thoughtful, deliberate sort of way. So what happens, first of all, when we're involved with safety plan services? Well, safety plan services are a time-limited kind of service package that helps us maintain safety within the family. Now, these services are only used during the child abuse assessment or during a China assessment, and they're only for 15 days. We can renew those one time, but they need to be done really by the time we're done with the child protective assessment. As opposed to family safety and risk services, next slide. which are going to promote positive change in the behavior of the family. There's a couple other things that we're going to be focused on as well with family safety and risk in permanency services. We're going to certainly be monitoring safety issues, the risk of maltreatment. We're going to be looking at the stability of the family, trying to
You're
support
viewing
that family
a
if we can.
lecture
Protective
held at
capacity,
the
building that protective
Iowa
capacity,
Department of Human Services on
and
how they
promoting
manage
permanency and,
cases
and
of
well-being for kids as well
child
as
abuse,
transitioning
particularly
older kids, into
what kinds of
adulthood.
services and
And
how
we're
they
going to do that in a
arrange
variety of
and
ways,
evaluate
and
services.
we're going to do that in an evidence-based sort of way. What's going to happen with families is that we're going to look at as many community services as we can find for families. Now, we have always looked at community services.
Mark
Those
Chappelle is
community
the speaker.
services aren't going to be anything new. But we're going to be much more planful in that. And I think we're going to be much more focused on looking at how we can bring those community services to bear for families, as opposed to simply buying service from the department that's going to go away in 6 months or a year. What that means is that families are going to have a lot more, and families and providers and the department are going to have a great deal more flexibility in terms of how we deal with things, and we're going to be able to hook families into a system that's going to support them for a long period of time after we're gone. We have limited resources. We always have to look at how we're going to focus those resources on the cases and in the areas where they're going to do us the most good. But we always know that that kind of thinking oftentimes leads us to a long period of involvement with families with the department. And that's not necessarily going to be healthy or helpful for them. The quicker we can get in and out, the better it's going to be for families. The more we can hook families up with community services, the more they're going to be hooked in with the community, and the better they're going to do, and the more they're going to be able to sustain whatever changes they've been asked to make. So how are we looking at, I've been talking a little bit about safety, and I've mentioned a little bit about risk. How do we make a distinction between safety and risk? Well, safety things are immediate kinds of concerns for kids. They're the kinds of things that are going to pose an immediate threat to a child. And those things can come from a variety of situations, I guess, which we would call, if kids were involved in a bad situation where there's hazards in the home, or there's meth in the home, or there's drugs in the home, or we have parental behavior problems, or we have depression on the part of parents, let's say, or there is some sort of perception that the child is not a good kid. He's a bad kid. He's bad seed. That somehow this kid's out to get me. Those kinds of things all can result in immediate safety risks to kids. In other words, something is pretty likely that's going to happen here. It's a lot of times what I draw is the distinction between a kid that's standing on a curb and a kid that's standing in the middle of the street. A kid standing in the middle of the street is in a safety situation, because there's more likely than not a car is going to come and bad things are going to happen. Risk is a longer term kind of thing. It exists in all families, in some families to a greater extent than in others. It is something we always need to be concerned about, but those kinds of things don't always immediately impact kids and families. It's the standing on the curb kind of analogy here. One of the things that I think we do have to be very careful about, though, when we focus on safety, that we also keep in mind that risk can be underlying. In other words, there can be internal things within the family that produce safety risks. There can also be things that contribute to risk that are external to families. Their financial situation, the neighborhood in which they live, the people who are around the child, the family that the child is born into. Any of those kinds of things can contribute to safety risks. So when we focus on safety things, When CPA comes out and they do an assessment, we move the case to service, we focused on these safety things that need to get fixed. We also need to think about what kinds of risk factors are there that are going to contribute to the safety concerns that we have, that if we don't fix, as soon as we're out of the family, those things are going to come back again. So we've always got to be thinking about that. But we are going to focus primarily on safety things. And that's what providers are going to be working on. That's what families are going to be working on. And we're going to identify those things pretty clearly with families. And we're going to do that. Go back to Beth's safety constructs here. Threats of maltreatment, child vulnerabilities, and protective capacities. The thing I like to think about with this is a dynamic balance. Protective capacities offset threats of maltreatment. Child vulnerabilities may contribute to protective capacities. They may contribute to threats of maltreatment. Threats of maltreatment are all the things that I just talked about, the child's situation, behavior, parents, all those sorts of things. And we we have domain language within our case plans. Best folks look at that as well. And we look at family safety things. How are we going to talk about that? When we're thinking about threats of maltreatment, we're in that domain. What kinds of things are going on with the family? When we look at child vulnerabilities, we look at child in the domain of child well-being, family interactions, home environment. What kinds of things are going on here that are going to present a safety risk or a safety threat to these children? In the protective capacities, we're looking at parental capabilities, family interaction, and home environment. All of those things are going to come together in some sort of common language that is going to be carried from our protective assessment, through our handoff, through our engagement with the family in a family team meeting, and ultimately a family plan, which is what we're going to use to help the family get where they need to be. It's going to be a family plan. They're going to have involvement in it. They're going to have buy-in to it. They're going to have investment in it. It's the only thing that is going to get families moved down the track to shorten their service horizon with us. So what's the safety plan going to do? Well, obviously, it's going to identify the safety threat that has to be ameliorated, made better, minimized, reduced, eliminated, whatever it is that's going on here. A lot of families, and in a lot of the families that we deal with, nobody talks about the issues. You know, it's a family secret kind of thing. We don't talk about those kinds of things. Sometimes we don't see those kinds of things within the families. Family members, they've been living with it so long, it's a way of life, they just don't perceive what the real threat here is, or where the problem with this is. Sometimes they don't hear what those threats are. Because we don't talk about them, people can't hear about them. Sometimes even when they do get talked about, people don't want to hear about it. Well, this is the way it's always been. So our job in the process of engagement with families and dealing with them in a family plan is to try to help them identify those things and get their buy-in that those things probably need some fixing. Then we're going to identify the behaviors or conditions based on the risk factors that need to be changed, controlled, or supplemented. I think that the key here in this is identifying behaviors and conditions. We're going to talk very, I guess, pointedly and in a very focused way with what kinds of behaviors need to change. Not just sort of, well, gee, it'd be great if these kind of things happen. These behaviors need to be fixed. These behaviors need to be changed. So families, when they come through this, and we're working on the family plan, hopefully what families will have is a very clear plan that tells them what they need to do. They can look at that and they can say, gee, you know, if I get these things taken care of, I'll be able to either get my kids back, or I can live, my kids can live safely with me. We're not going to have department involvement. We're going to be a better family. But they'll know very clearly what it is they need to do. The other piece of this is the providers are gonna know very clearly what it is they need to work on with families. So there's not gonna be this confusion about whether I got a baton, a mop, or a lamp. We're all gonna know what we're working with. And hopefully it's the, it's the baton kind of thing. So who are services gonna be available to? Thanks. Who are services gonna be available to? Well, services are available to intact families, children who need safety maintained within their own family. They're going to be available to kids who are whose goal. Sorry, I can't see that quite. For whom the goal is achieve or maintain the alternative permanent family connections. These are going to be kids who are disconnected from their families but need to move on, and we need to get them into some sort of permanent kind of living arrangement. They're also going to be available to family and group care kids, foster care and group care kids who are getting treatment in a facility or some sort of residential setting and are going to be coming back home at some point. We can plug these services in, make sure that the transition home is good for them, and it's going to be a constructive environment when they get back home. It's going to be a situation where they're not going to just turn around and go back into the same kind of thing. Because we don't deal with things from a system standpoint. In other words, what kinds of things are going in the home that contributed to the child leaving. Then when they come back, they're going to be faced with the same thing. We're probably going to see the same kind of outfit, or we're going to see the same kind of outcome. So when I think about all of this, and I think about where we are today, I think we've got a good ship. And I think we've come a long way towards turning ourselves into the kind of a service system that is going to serve families very well from start to finish. It's based on engagement. We have a common language. Everything we do is based around those constructs. Everything we do is moving towards permanency with families, towards safety with families, and letting families know exactly what it is they need to do to get where they need to be. So, today, when we work with families, instead of giving providers instructions about where they need to turn, how fast they need to go, when they need to take a time out, what we're going to do is tell providers, just get me to Southern Iowa. And I'm not, and how you do that is up to you. We want a certain outcome, and the outcome is the amelioration of the safety concerns. Now, what providers will do with that is they will use evidence-based practice to achieve those outcomes. They won't just be going off, doing whatever it is they think feels good or looks good, or the latest thing that they read in some pop psychology magazine. It will be evidence-based practice. And our providers have already given us some presentation about the kinds of things that they're going to be using. And I'm frankly excited about that, because we have now been able to give providers the latitude to do what they need to do and give them the tools to do that in an environment that will pay them reasonably well to get those things done. And we don't have to worry about, gee, how do I get this service, or how do I bend that around to make this work for the family. Providers can do what they need to do, and we'll be happy, and the family will be happy if they get to that outcome. Thank you very much.
Can I ask a question? Back to Beth and Wendy, I believe, is it? We're talking about the family.
The target audience here has been the Council on Human Services. This is an organization appointed by the governor to look over the affairs of the Iowa Department of Human Services.
Uncle was going to pay the rent. And it's evident to evidently the worker that's gone into the home that the mother is a meth user. But there's no meth situation set up there to produce meth.
Vocal invites you to
What
return
do you do? What
to
can you do
see this program
to get-
next
because
week.
If the child isn't being taken care of, and she's not even keeping her